Well, now to the fallout from today's rejection of a proposed constitutional amendment that would have legalized abortion in Arkansas for up to 18 weeks of pregnancy, while also expanding a list of exceptions for the procedure to include cases of rape and incest. Channel 7's Emma Allen joins us in our studio now with the details. Emma.
Good evening, Chris. Today I spoke with Robert Steinbuck, a law professor at University of Arkansas at Little Rock, who explained the legal reasoning for why these petitions got rejected. The Arkansas Secretary of State John Thurston rejecting a proposed amendment for Arkansans for limited government, a group aiming to incorporate an abortion rights amendment into the state constitution. The reason? Well, Thurston said the group failed to identify their paid canvassers and failed to establish those canvassers had been properly trained. I sat down with Robert Steinbuck, a law professor at UA Little Rock Bowen School of Law, to get a better understanding of the rejection.
The law says for the penalty, so to speak, for not fulfilling those requirements is any signatures gathered by the paid canvassers who haven't satisfied one or more of these rules shall be stricken.
Arkansans for Limited Government initially submitted nearly 102,000 signatures, but that number was reduced to just over 87,000 because Thurston said many signatures did not meet requirements under state law. So what happens next?
I've heard differing opinions as to whether or not the folks behind the amendment could submit that affidavit late now and say, oh, well, here it is. We forgot. And I've heard some legal opinions that said that is sufficient. And other legal opinions say, no, the law doesn't provide for a cure.
Ultimately, Steinbuck says it's up to the courts.
The statute says nothing about a cure period. So does the absence of a cure period in the statute mean there is none? That's one interpretation. Or is one implied in the statute the way one is explicit for other issues in the Constitution? And ultimately, that question would only be answered by the courts, working its way up, presumably, to the Supreme Court.
Well, late tonight, Arkansans for Limited Government released a statement saying they were alarmed and outraged by today's decision. They say they worked closely with the Secretary of State's office and that the assertion that they did not file the proper paperwork is quite absurd and demonstrably, undeniably incorrect. They vowed to fight what they called a ridiculous disqualification with everything they have. On your side, I'm Emma Allen.
Okay, Emma, thanks so much for that. There was a reaction to today's decision from the other side of the aisle as well, including from Rose Mims, the executive director of Arkansas Right to Life. Rose says, quote, "We appreciate the diligence of the Secretary of State in the certification process. Though this measure has failed, we expect this is not the end of efforts to once again make abortion legal in our state." And there's this from Attorney General Tim Griffin. He says the sponsors failed to follow the law, specifically a simple and straightforward affidavit requirement that other ballot committees followed. Failure to follow such a basic requirement, he says, is inexcusable. The abortion advocates have no one to blame but themselves.